So, I don't know, but I would need some direction from the board on that, you know, before I move forward with revising the plan. Let's see, 4341 is the culvert pipe here. The regulations say we need a 3-foot cover over the pipe. I think, again, those regulations were written back when everything was reinforced concrete, class 3 pipe, which needed a lot more cover than some of these high-strength polyurethane pipes that are being used now. Manufacturer's recommendation on the pipe that we've selected is 12 inches, which we are providing in this location. The issue we're having here is in order to get the water to drain from one side to the other under the road without having to go over the road, we need you know, the minimum amount of cover possible. Otherwise, we won't be able to, you know, we'd be too deep, we'd be down into the water table to try to get a pipe, and then it wouldn't flow where we need it to flow.
So how much cover will you have?
Minimum of 1 foot, like just over a foot on that pipe.
Well, I think that part of the cover requirements, you know, when these regulations were changed, I mean, we were aware of the different types of pipes and, you know, and the, you know, the options in the pipe. So part of it is also providing clearance for other utilities and, you know, reducing conflicts in drainage design and utility design. I mean, the question would come in, then how are you gonna bring your underground electric in if you've got less than 12 feet or 12 inches of cover?
We could go underneath it.
You'll go underneath them,
Yeah.
okay.
Yeah, and it's gonna be so shallow that we could run those services underneath the drain pipe.
I don't have a big, concern with that one. The first two, I'd like to see, you know, a little bit more work on the basin, because I feel that in some areas, the basin gets very narrow, it's very irregularly shaped, and it gets very narrow in the bottom, so I'd like you to address all the, you know, all the other questions regarding the basin design with, you know, provide the freeboard and all the other requirements of the stormwater standards, and then we can look at that. I think, as long as we know it can drain down and flow out properly, then, you know, there could be, you know, considerations for those waivers.
Yeah, and, you know, certainly, I mean, it doesn't have to be perfectly flat in the bottom. We could provide some spot grades within there to show that, you know, the water will be directed where it needs to go.
It just seems that some of the contours are really neck down, so it's only
Yeah.
like a foot or two
Sure.
wide, that could easily get blocked.
Okay. Let's see, the fourth one, section 4511, is a requirement for sidewalk on one side of the roadway. My opinion on that is that, you know, we're talking about a 4-lot, basically a 4-lot subdivision using the new roadway. So the amount of vehicular and pedestrian traffic that are gonna be in this area is really gonna be minimal. You know, to require a sidewalk on a subdivision this size, I don't believe it's necessary. Usually on smaller subdivisions that I've done in the past, you know, it's one thing that can be waived. The benefit of waiving it is also, there is a drainage benefit. You're reducing the amount of stormwater runoff that's generated as part of the subdivision. So,
We had a 3-lot subdivision proposal before us, and they asked for that waiver, and we said no because of the precedent that it had set. So I'm not speaking for myself, but I don't see that that's going to get waived. But again,
I was just thinking the same thing,
Me
Jeff.
either.
We've required them on subdivisions of that size before.
okay. Doesn't hurt to ask, right? Number 5, section 3340, the requirement for a development impact statement be prepared as part of this development. Again, going along those same basic principles, the size of the development, it's really not gonna have any measurable impact on the community. And even in that section, the regulations, it says in the case of subdivisions containing 20 or fewer units, the board will normally waive some or all, you know, of the criteria that need to be analyzed in the development impact statement. So.
I don't think in the past we did that requirement, have we?
I don't remember. I'd have to.
Tony's Way,
That was, I can't remember if we waived it for Tony's Way or not. I honestly can't.
Can you
That-
look at?
That was a 3-lot, right?
We're just in the discussion phase of all of these anyway.
Right,
so,
right.
So we'll
has impact on stormwater and wetland issues.
Which are already kind of being addressed with the, drainage report and stuff like that. Wetlands, obviously, would be filed with conservation, with this plan as well, so they will have a chance to look at it, but, the normal stuff that's analyzed with a development impact statement, like schools and stuff like that, I really don't, see this project, and again, I think it's why the regulation is worded the way it is, in the case of subdivisions containing 20 or fewer lots. But obviously, that's your decision and not mine.
More comments from the board before we open it up to the public?
I had one other question. Now, did you, I seem to remember that there were additional waivers that were initially being requested besides those listed there, or am I wrong?
Yeah, I mean, them, you mean on the plans themselves?
Yeah, I thought you had listed some of the plans, too, if I'm not mistaken.
I don't believe,
You had, okay.
I don't believe so.
That's a different set of plans I was looking at.
Yeah, there might have been some that were talked about at the preliminary stage, maybe it was a preliminary plan that had.
All right, if I'm not mistaken.
But certainly, I mean, these were just, I just was going through your letter today, so I put these together, as being issues that would affect, revisions that need to be made right away. So I was hoping to get some input on those, but, there could be other,
There could be
Uh,
subsequent ones
yes,
after you
exactly.
fully, okay, examine what's
yes.
required.
Other comments? We'd like to open up to public input. If anyone would like to say something, please state your name and then tell us what you think.
Liz Schwell, and all he's doing here is pushing everything into my property.
Which is yours?
I'm around everything he's doing, except for the one way in the back. And number one, if there's a problem, who's gonna help me out? Not him.
It's on here.
The water all comes my way. Number two, there's so much crap in that ground, it's not even funny. What are they gonna do with that when they dig it up? Hide it? There's oil tanks under there, everything. Paper took when he bought my dad's farm, the big barn went with it. There were oil tanks in there were pot-belly stoves, you name it. 10 o'clock every night. The trucks would come out till midnight. There's a lot of crap there, and it gets pushed, and that pond that's there is not the right size pond. And that pond, because I'm not saying nothing against Mr. Wilson. He did not do any of this. You guys know it was painful. He filled all those things in. There was a well back there to the right of that pond. He filled all that in with his crap. And I just see this project turning my property into a nightmare. And who am I gonna turn to? And I don't like it. I don't think it's fair.
My name is Deb Wagner, and I live there also, and that culvert he's talking about cannot handle the water that comes through there now. It's not really maintained by anyone. If anybody fixes it up, it's me putting rocks there and digging the stuff out of the culvert because all the sand and everything gets in there and plugs it up. And you can even see it on the road, you get the potholes and everything because the water has no place to go and it also erodes the road away. The water does drain through the road into Swansea, but what there is there now is not adequate. And when it rains a lot, the whole field will be underwater. And I can see that becoming more of an issue in the back as well by the pond.
And there's nothing there but rocks. You take those trees down, which they're gonna have to. You're gonna
There's
open up
nothing.
the floodgates. You're gonna have to build a dam, never mind a holding tank. Because it's all rocks. My great uncle bought that property years ago, back in 1920s. It took him 2 years just to dynamite before he even started building there, cause there was so much rock. It's all still there. The water, what little water that doesn't get down is the trees that are there hold all that in. I had friends that had a neighbor that had all these trees, they cut them all down, their basement flooded, their house was fine, but their basement flooded. I don't wanna be dealing with these issues, I just don't think it's fair. Unless they can put in writing, they'll pay for anything I think is wrong.
We're gonna fix.
Jeff, has there been any environmental studies on the pots and tanks or whatever?
No, but we have been out there, we've dug test pits as witnessed by the Board of Health on all these lots. We've run across some fill, we're not gonna say that, like over in this location here. But no, we haven't run across anything that would indicate like illegal burying of stuff. Now, we haven't, the areas where we've dug, and it's probably important to note, is that the way we're proposing this, there's an existing field out here, existing field over here, existing field over here. It's kinda clear around the house, and then this is all woods in the back. We're really not taking down many trees to build this. This house is going in the field, that house is going in the field. This one will require some clearing of trees in this location, but this is about the only one, that will. The rest of them are all in the open fields. So, and again, we've done, probably over 20 test pits out on this property, and we haven't run across any.
Where is it that
15 feet down.
she's talking about the bin or the oil tanks and
I
stuff?
have no idea.
Where did you think the oil tanks were?
They're right in here.
These like home-size oil tanks that you're thinking
Yeah,
of, or
you know,
big?
farmers in those days, cause when my dad owned the property after my great uncle, the farmers came, they needed oil tanks for this and that, and they just stayed there. I mean, you drive around old timers in Dayton, you see things like that everywhere. Then all of a sudden they're gone, and every night at 10 o'clock at night, the green lights would come on, and my mother would hear all this plowing and digging, and he had, I don't know if you guys ever went out there, he had a berm as high as this building out there, which I ended up taking down. And took
Because
stuff
most
out
of
of
it
there,
on
yeah,
property,
I mean, I
yeah.
got, should've brought the pictures. But all kinds of junk. That
Even in the pond,
that
there's
little
all sorts
pond
of
is
stuff in the
there's
junk.
there's already like an oil scum thing on top of it. It's terrible, we're constantly cleaning up, we're constantly, trying to do our part. I mean, I don't mind people doing what they want, but, it's just not gonna be fair. That property is all crap, and it's all gonna come our way, and I just don't think it's fair. And no one's gonna care. Once you say okay to this guy, no one's gonna wanna listen to me. I know, 'cause I've seen it, I read it every day in the paper. The little guy gets hurt. Now, why that man, Wilson, didn't turn that into a horse farm or a solar farm and made tons of money and nobody would say boo is beyond me. That property is not for development. In my opinion, Payne should never even put that house there.
I mean, it's important to know everything they're talking about wasn't done by the applicant, it was,
I said that
whatever
right
was
away,
done.
sir.
No, I know,
said
I'm just,
nothing with Mr. Wilson, I'm
Yep.
saying the name Paver.
which I believe was 2 owners ago, if I'm not mistaken.
Yes, you're
Right.
correct. But the second owner that bought it found out all this stuff, like the minute after, the guy never even put a picture up on his wall, he was so upset, and then he sold it to Mr. Wilson after a year and a half.
So I think
I
at this,
mean, if I could suggest, if I could meet with Jeff and the owner of the property and go along that side of our property and review proposed work and make sure that there isn't any possibility for impacts along that side, if the board would.
that'd be
That'd be
helpful.
fine with me, it'd be great.
I like that idea.
But in order to dig a house, you gotta go down how many feet?
But what I'm saying, concerned with the runoff onto your property, I could meet you out there with the engineer and we
I
can look
understand,
over.
but when you dig a hole for a house and come across a
Yeah.
problem,
Well,
now
that's.
I can almost
that's a-
guarantee,
Okay, we understand that, but that's a requirement of any project within the state, that if they start digging and they find problems, it has to be reported to the DEP, so it's properly handled.
yeah, if they report it.
Well,
A
the
lot of people don't
contract-
report things.
well, I think more these days when people, people are building properties, say someone's gotta put a house on, they're not, the developer has to be responsible in saying that he can't, you know, put someone's house in an area that's, you know, has soils contamination issues. Cause he's gonna be looking for problems down the line.
In other words, the guy that's digging the hole is not the owner, and it's in the digger's interest to report it, because if he doesn't, all of a sudden, he's liable as opposed to the owner, so any contractor is not gonna just turn a blind eye unless the contractor's also the owner and owns all the different subcontractors, and very unlikely that something would go unnoticed these days. Now, back when you're talking about the tanks and the
Right, right,
nighttime
yeah.
activity, well, those days are long gone, thank goodness.
But how long ago was that? I mean, how, with Pavo? I mean, you're talking nineties,
No.
before or after?
Between 1999, 2000, because when he had that berm there, he's out there doing something, I happened to be there one day before I took over the property, and so I went up on the berm and I'm snapping away pictures. He gets out, what are you doing, what are you doing? I said, well, what are you doing? All of a sudden, then he
Well-
starts talking about Miranda, what a rotten guy he is, of the paper road, and he won't sell the land, blah, blah, blah. He just changed the subject.
And the other thing he did was he filled in that pond area. And, we had photos that it was there and they redug it out, but they did not dig it out adequately. And there was all sorts of stuff buried under there that you could still see, plastic and everything.
I mean, we're talking about activity that was done fairly recently, with basically the same regulations that are in effect now were in effect then. You know, DEP could have got involved, I'm sure did you notify the town at all?
He didn't tell anybody,
or-
cause he had he had like
Well, obviously he
land-
didn't, but I'm saying-
Yeah, he did it all in the, you've
Okay.
been there, you know how
I-
isolated that place is, you
Yeah.
could kill somebody up there and never, and bury him and never know the whys, it's so isolated.
So it might be a good idea not to look.
No, I know there was an issue with conservation, cause when we went in for the, to establish the wetland line, they had some questions about that because of some previous activity that was done.
Right. So the pond isn't anywhere deep enough where it, had the spring, so there's all sorts of issues with that as far as you're talking about drainage, if it isn't dug deeper is kind of what I'm saying. So it was
Well,
never, when it
no,
was
we're not
filled in,
touching-
they didn't really dig it back
But
out
we're not proposing to
properly.
touch the
Right.
wetlands or within 25 feet of the wetlands or anything like that.
But if you put a holding tank or something there, then it's just gonna block it up even more when we have a lot of rain and it's gonna flood the
Are you-
back of our
So you're
property.
talking about the constructed wetland detention facility? Yeah, I mean, that's basically designed, again, to hold the water and discharge it into the wetlands at the same rate it's being discharged now. Ultimately, if this is designed right and gets constructed right, you shouldn't see any changes. That's
Unless for
the
the
principle.
positive.
And we don't know who the contractor's gonna be if this goes through, is it gonna be you?
No, I'm not a
There
contractor.
you go, your job's done.
No, but the board will have someone overseeing the work to make sure
I
that
hope
it's done
so.
properly.
You can hire me, cause I'll be there 24/7 watching the whole thing, and I'll do it for
You
free.
should.
So if you wanna give, the board your phone number, we'll contact you and set up the time to meet with you.
Mr. Chairman, I came across this letter in the packet that I didn't know was there,
Bob.
and I think it's important that it be read from pillar and pillar.
Read into the record,
Yes.
okay? You wanna do the honors?
I'll do it. And this is from Killeran and Killeran, attorneys at law, 350 North Main Street, Fall River, to the Dayton Planning Board, regarding definitive subdivision plan for Wilson's Way, Dayton. Dear Sir, Madam, please be advised that this office represents Kenneth Barrowby and Kim Barrowby, who reside at 3177 Shopside Road, Dayton. Please be further advised that Mr. and Mrs. Barrowby directly abut the proposed subdivision to the north. Upon our review of the definitive subdivision plan, also called the plan, we do note that the plan is fatally defective. Specifically, I bring the following to the board's attention. Number one, the plan sets forth that lot one has 253.06 feet of frontage. Upon our review of the plan, it is clear that lot one only has 233.54 feet of frontage along Shopside Road. It appears that the developer is including part of the turn-in radius for Wilson's Way as frontage for said lot one, which is not proper. And this is something we discussed a moment ago. I would direct the board's attention to the definition of lot frontage of as set forth in the town's bylaws, which states that the frontage is to be measured continuously along a single street. The frontage for lot one as measured along a single street in Shopside Road is only 233.54 feet, and thus the proposed frontage does not meet the bylaw requirements of 250 feet. And that goes on to say, in certain circumstances, the bylaw does allow for frontage to be calculated along two intersecting streets, but only if the angle of the intersection is greater than 120 degrees. Here, the angle of the intersection between Shopside Road and the proposed Wilson Way is approximately 90 degrees, and certainly is not greater than 120 degrees. Accordingly, the developer cannot use any portion of Wilson's Way to calculate the frontage for lot one. Thus, lot one does not comply with the town's bylaws again, as it does not meet the 250 feet frontage requirement. I don't know if you can modify that radius there, but, we're talking about that right now, the road going in.
Can I get a copy of that? Do you have an extra
Sure.
copy?
Reading number 2, proposed lot 5 as shown on the plan is also defective. Said lot 5 is best described as a pork chop lot. As designed, lot 5 has 250 feet of frontage along the proposed Wilson's Way. However, 160 feet of that frontage is beyond the westerly side line projection of lot 5 and is situated in the handle of the pork chop. It goes on to describe pork chop lots, and he kind of agrees with the position that we took, that is indeed a pork chop lot and is not eligible. Number 3 talks about drainage parcels number 1 and 2. Do not conform with the rules and regulations of this board, as the drainage features are not set back at 50 feet from the perimeter lot lines that existed prior to the submission of this subdivision application. Of particular concern is that the drainage features within drainage parcel number 1 are located within a few feet of my client's property. Is that shown on there?
Yeah, that's the zigzag on the north, is it north or south side?
North side.
North side.
Okay. Oh, yeah, I see it, right side of the road. What is particularly troubling is that the well serving my client's property is situated approximately 23 feet north from the mutual boundary line separating drainage parcel number 1 and my client's property. As I am sure this board is aware, detention basins are often catch contaminants from water runoff, and having these contaminants within such close proximity to my client's well is deeply concerning. The developer should be made to comply with this board's rules and regulations, and any and all drainage features must be situated at least 50 feet from existing property lines. Note number 1, as set forth in the subdivision plan, states that the proposed definitive subdivision plan is the result of a preliminary subdivision plan approved by the Dayton Planning Board on January 21, 2015. Please be advised that my clients never received any notification that a preliminary plan was filed, and if so, they would have made these same objections at the time. I can advise that my clients are not opposed to the development of the land at issue. My clients do feel, however, that the proposed subdivision must comply with this town's zoning bylaws, the planning board's rules and regulations, and the laws of the Commonwealth of Massachusetts. Unfortunately, the plan falls short of those requirements, and this plan in its current form must be denied for the reasons set forth herein. if the property owner redesigns the subdivision and is able to comport with the town's bylaws, this board's rules and regulations, and the laws of the Commonwealth of Massachusetts, then the Barrowbys will not oppose such a plan, so long as their property is not endangered by this development. He goes on to state he is unable to attend the board's hearing, please feel free to contact me. And that's, Killoran's and Killoran's view on the subdivision. This probably ought to go to our town
Can I just address those
legal
issues?
advisor too.
The, alright, so number one that he has in here, the frontage on lot one, again, that was something that we spoke to Jim Aguirre about, and the way this is looked at in the town is half that radius goes towards this lot. What they're talking about here was, if you were proposing to use frontage on two streets, continuous frontage. So in other words, if you had a lot that had an angle of, say, 145, and you had a lot line on one street and a sideline on the other street, you could use all that frontage. You could use 250 feet of that roadway as continuous frontage. They would allow that, even though it's on two streets, because of the angle. All we're doing here is taking this radius and saying, okay, half of it goes to shop lot, the other half goes to the subdivision road. It's an entirely different case than what they reference in number one. We're not trying to take credit for the other side. If we were trying to take credit for the other side of that radius, they would have a point, but we're not. We're just going up to the center line of that radius. Number two, being lot 5, is something that we spoke about, and obviously you're gonna get a legal opinion on. Number 3, parcels 1 and 2, the 50-foot setback. The regulations, best I can tell, we're talking about locations of detention, retention, infiltration basins in section 4312, which apply, the 50-foot setback applies. But again, it's specific, detention, retention, and infiltration basins, not swales. Swales do not apply in that case. And then number 4, the preliminary plan, we had gotten a certified abutters list that was submitted along with that application from,
Excuse me,
yep,
preliminary plan, you're not required for notification, only if it's tentative.
no. I thought we had gotten a certified abutters list, maybe it was zoning application or
Let's figure that one out.
conservation might have been at the time. So, but I know, I wanna say there were abutters that showed up at the preliminary stage. So, I mean, the 4 items that he has in here, obviously with the one issue being lot 5, which we already talked about, we'll get an opinion on that and move forward, but the other 3, don't apply.
I would only comment on that the back detention pond might be within 50 feet of the existing property line. Down that bottom corner.
Over in here?
Yeah.
Yeah, that's something we can take a look at, okay, address if need be.
But I would agree that the front is not a detention retention basin, it's basically a swale. It's a regular swale, but it's a swale. And you could just change that to a ditch.
Can I use yours for a second?
Well, yeah, it's different.
6.
What's your road length?
600.
600 feet.
It's 600, and the preliminary it was longer.
No,